Hello everyone, and for those returning to a need-to-know basis, welcome back. In our last video, we spoke a little bit about journalism and its role within the democratic society that we find ourselves living in. Journalism, in one form or another, is something that plays a vital role in how a democracy works and sheds light on things that would often go unreported or be unknown to the public otherwise. However, while journalism does serve democracy in this fashion, it can't do so unless said democracy is willing to help protect it as well. In the United States of America, journalism and democracy have a very symbiotic relationship that, without one, the other would be non-existent. Without clear reporting and unbiased information, a democratic society would falter. Without some democratic protections, journalism would be a field either stifled by reckless censorship or filled to the brim with yellow journalism. This is why the following amendments to the United States Constitution, as well as other acts, exist to protect it. Let's start by talking about the most hotly debated amendment that provides the foundation for journalistic protections, the First Amendment. It's something that many people cite when talking about the issue of freedom of speech, but unless you're someone who works closely with it each and every day, it's not often you get familiar with the actual language of it. The First Amendment states, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or the press, or the right of the people peaceably to assemble, and to petition the government for redress of grievances." As can be seen from those words taken directly from the Constitution, the First Amendment protects free speech and a free press. It also ensures freedom of religion, assembly, and petition, but the freedom of speech and press are those directly related to journalists in this course. Also to note are the very first 5 words of the First Amendment, "Congress shall make no law." What this means is that Congress cannot make any laws that will hinder free speech and the free press. Specifically, the amendment is talking about the government, not private citizens or companies. For example, when a private company decides that it will censor certain speech by their employees, this is not a free speech matter protected by the First Amendment. If, however, Congress tries to enact laws that censor certain topics from being discussed or printed within the media, that is a matter covered by the First Amendment. This is a very important distinction. The First Amendment protects citizens against government censorship. It does not protect citizens against private individual and private company censorship. The First Amendment provides protection for the press by ensuring that the government cannot censor material before it is published and by ensuring that journalists and publishers do not face criminal charges for what they publish. Censoring material before it is published is called prior restraint. Prior restraint would only be allowed under extreme circumstances, such as protecting national security. An example of acceptable prior restraint would be preventing the publication of upcoming U.S. military troop movements. By publishing that information, the journalist and publisher would not only be endangering the lives of the military troops, but would be endangering national security. Other than for national security, prior restraint is not permitted. Journalists and publishers are, for the most part, free from criminal charges for what they publish. They are not held criminally liable, but they can be held liable for civil charges, for example, being sued for libel, slander, and defamation, of which will be discussed later. As stated before, free speech is a very hotly debated topic that, in some cases, very few people know little about. As a journalist, this kind of thing may or may not become a very common question when it comes to what you're right about and why. One thing that you should also consider when it comes to free speech is that, while you can't be stopped by the government technically, that doesn't mean you aren't free from the consequences of what you speak either. As a journalist, this is even more important, as what you write about may have the ability to reach hundreds, maybe thousands, or even possibly millions of people. What you report about can become the basis of someone's research paper, or be the cornerstone of someone's belief system. Don't forget one important factor too. Whatever you say online, on television, or through any publication will be there forever. Are you willing to be known about what you write about professionally or for fun? Free speech means an infinite amount of consequences. Make sure to use it wisely. The Sixth Amendment states, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial, by an impartial jury of the state and district wherein the crime shall have been committed." The key phrase, pertaining to journalists, in the Sixth Amendment is, public trial. There are 2 main reasons for the public trial stipulation. These reasons are, as stated by Justice Brennan and Justice Marshall, open trials assure the public that procedural rights are respected, and that justice is afforded equally. Closed trials breed suspicion of prejudice and arbitrariness, which in turn spawn disrespect for law. Public access is essential, therefore, if trial adjudication is to achieve the objective of maintaining public confidence in the administration of justice. Without open trials, open to the public and open to the press, how would the public know that justice is being served equally among all citizens? The public would not be allowed access to all the information that was revealed during the court proceedings. Evidence could be potentially kept secret, witness identities could be kept quiet, and the full extent of the charges being filed could be filed away. If all of that information is kept secret, how does the public know that the court ruling or the sentence given are justifiable according to the law or fair when compared to similar crimes? This secrecy would produce not only great distrust of the judicial system by the public, but could potentially lead to abuses by the courts and individuals within the judicial system. The second reason for public trials, as stated by Justices Brennan and Marshall, is the simple fact that the public has a stake in the process. A civil trial is a person versus a person, but a criminal trial is that of the state versus an individual. That distinction is very important. A criminal trial involves the state, and the state represents the people. Citizens are the people. Therefore, the citizens have a stake in the trial. Also, public funds are being used to try the case, and it is the public's right to know how their tax dollars are being used and if they are being used efficiently. For high-profile cases or cases that have stirred the anger of a community, allowing all of the public who want to attend would be physically impossible and a potential danger to those involved in the court proceedings. In order to alleviate this concern, and still meet the constitutional requirements of free speech, freedom of the press, and a public trial, the press acts as a surrogate for the public in most situations. The press, journalists, are allowed the same rights and access to the trial as the general public. The press are not provided or given rights, different from or greater than the right enjoyed by the public. In performing their duties as a surrogate, journalists then report on the proceedings, providing the public the information needed to ensure a just and fair judicial process. There are times when the courts are concerned with public access to the trial, either in person or through their surrogate journalists. In high-profile cases especially, the court's concerns are that the jurors can be influenced by the media's reporting and presentation of the trial. News media presence could disrupt the decorum of the courtroom. Widespread media coverage could negatively affect and influence the defendant, witnesses, and even the victim. Although these concerns are valid, the Supreme Court has ruled that the constitutional guarantees of free speech, freedom of the press, and a public trial override these concerns. In Shepard v. Maxwell, 1966, and Richmond Newspapers v. Virginia, 1980, the court stated that to avoid disruptions of the trial due to public and press access, the judges must use other means to ensure an orderly trial. These other means can include moving the trial to another venue or location, for example, to another county, or sequestering the jury so they have no access to outside influences during the trial. Let's move on to another important, if lesser known, amendment that goes past the top 10. The 14th Amendment's Due Process Clause states, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws." Prior to the 14th Amendment, the Bill of Rights only restricted actions taken by the federal government in regards to the constitutional guarantees of freedom of speech and freedom of the press, and others. Although the federal government could not restrict freedom of speech or freedom of the press, individual states could. In 1897, the 14th Amendment was passed and certain provisions within the Bill of Rights were applied to the states via incorporation. Incorporation, put simply, means that certain constitutional rights were now applicable to the states as well as the federal government. This one is a little more specific, though very important if you're in the line of work that ends up working very closely with the government or government officials. This one deals with the Freedom of Information Act. The Freedom of Information Act was passed in 1967 and allows the public and press to have greater access to federal records. Any member of the public or press can request federal records from any federal agency. This act is meant to provide better transparency to the public. The federal agencies are required, by law, to disclose requested information unless the information falls under certain exemptions, such as national security, law enforcement, and/or personal privacy. So, what exactly did we learn here today? Let's see. 1. The First Amendment protects United States citizens, and especially journalists, from prohibiting free speech, at least on the federal level. 2. The Sixth Amendment provides the right to a speedy, public trial, which is important for journalists who report on what goes on in our courtrooms. 3. The 14th Amendment protects the rights of citizens on a state level, making sure that no rights are abridged and abused. This extends the power of free speech, as well as the other rights given in the Constitution. 4. The Freedom of Information Act can, under specific circumstances that don't endanger national security, law enforcement, or personal privacy, allow a person to gain access to federal records, an important tool for any journalist. As stated before, the democracy that supports the United States would not survive without the watchful eyes of the press, but also needs to protect said press when it comes to certain freedoms. Every amendment and act mentioned before plays a vital role in how the press is able to function, and it's important to know your rights if ever confronted for what you publish. Make sure to keep these in mind as you continue to develop your journalistic career, and we'll see you in the next video of this series.